time over Zoom with incumbent Judge Melissa Saragosa, Justice Kurth Court before. Her opponent is not going to be here. She canceled recently this morning with Steve. So, Judge, what we'd like to do is just give us a little bit about you and your background, and then we'll put up the panel of questions.
Okay. Well, I guess I'll start with post-law school and my legal background. I'm originally from the East Coast. I grew up later in Arizona. Went to the University of San Diego School of Law, graduated in 1993. I've been practicing law for 22 years. My first job out of law school was as an active duty Air Force JAG. I served 5 years active duty at Luke Air Force Base in Arizona, doing a variety of areas: claims work, labor law, military justice, administrative law, a number of areas. And then I was transferred to Travis Air Force Base in Northern California, where I was made a circuit trial counsel. I traveled around the West Coast and prosecuted courts-martial cases as a senior trial counsel all along the West Coast. Part of that job was also to train the junior counsel at the base level on trial advocacy and prosecution. So after 1999, I separated from active duty and I went into the reserves. In the reserves, I have worked a variety of jobs. I've worked as a circuit prosecutor again. I've worked as a civil division instructor at the Air Force JAG School in Montgomery, Alabama at Maxwell Air Force Base. I've been assigned at the legal office here at Nellis Air Force Base. And I've spent the last 5 years as an appellate judge with the Air Force Court of Criminal Appeals. My current assignment is in transition, getting ready to go to 8th Air Force, which is at Barksdale Air Force Base in Louisiana within the Global Strike Command, and I'm just kind of in transition right now. I also do a lot of extra work with what we call our Air Reserve Component Advisor to the Judge Advocate General of the Air Force, and helping with recruiting and any reserve issues that come up with the JAG Corps. I'm a Lieutenant Colonel in the Air Force Judge Advocate General Corps currently, and that's kind of sums up the majority of my legal experience. I actually left out one of my assignments as a reservist. My first assignment as a reservist was at Aviano Air Base. I lived in Italy for 14 months, and I traveled all over Europe, in Chelini Air Base in Turkey, Geilenkirchen in Germany. I worked some in DC. I was there during Allied Force when it first began. And so I've done a number of roles at various levels, working with a number of international issues, staffs and forces agreements, and the like. In 1999, when after my 14 months in Italy, my now ex-husband, who's also an Air Force reservist currently, he was still active duty at the time, he got an assignment to Nellis, and that's what brought us to Las Vegas 15 years ago. I began working in the district attorney's office. I was originally a law clerk, kind of starting my career over again as a civilian to try and keep our family together, as we were a military family. I worked then as a deputy district attorney in the domestic violence unit. I worked on the general litigation team, and in my last year at the district attorney's office in 2006, I worked as the chief deputy district attorney of recruiting and training. So I was responsible for supervising summer intern program, training all of our new deputies, and trying to recruit the best candidates for our office. In December of 2006, I applied for and was appointed by our Clark County Commissioners to fill a vacancy in Department 4. I took the bench January of 2007, and I've been in my position since then. Since I've been on the bench, I have worked a dual criminal and civil caseload at times. I've been a civil docket judge for about a total of 3.5 years, a year and a half at one time, 2 another time. I began our first domestic violence court in the state of Nevada, and I did that for 2 years. I've served as our vice chief judge. I'm currently serving as our civil presiding judge, although I have a criminal docket. And I also preside over our Veterans Treatment Corps program, which is a diversionary program for veterans who find themselves in the criminal justice system. And my treatment program is an alternative to incarceration. We take veterans and connect them with services. These are veterans that suffer from mental health issues, potentially post-traumatic stress disorder, traumatic brain injury, and sometimes substance abuse issues that go along with that. I think that pretty much sums up my legal career.
And Tim, please begin.
My name is Tim Patara, former corporal, U.S. Military Police, U.S. Army. So here's my question for you. So dealing with, first of all, I want to welcome you home. Thank you for your service. I appreciate the fact that you've worked with the JAG. You know, on my end, I work with the JAG as well in my duty in the Army. So here's my question for you. Do you feel your experience in dealing with the Uniform Code of Military Justice has benefited or affected negatively or positively your work in the civilian side? I know there are very much different approaches and rules and regulations, and I know that can be definitely kind of two different roles from when I transitioned. So I'm just curious, and from as far as your judgment, do you feel it helps you in doing your job, or it's kind of like a not a distraction, but it's negatively affecting your job as a judge?
Well, I definitely don't think it's negative in any manner. I think it is important for us to broaden our experiences. One of the phrases you may have heard, or at least it's an Air Force phrase, is, at my last base. And everyone always wants to do things the way they did at their last base. And that's not a good way to proceed. When you broaden your horizons and you broaden your experience, you may open your mind to a better way to do something. And so I think not just my experiences with the Uniform Code of Military Justice, but overall my experience in the military has given me a broader base on how to train paralegals, how to work with your staff. It teaches you something else that I think is important, and that is just because you're, let me put it in perspective. When I was a lieutenant, one of the very smartest things and things I remember was I was told by a group of reservists that I went through my initial training with that just because you're a lieutenant and you're an officer doesn't mean you have the experience yet. So trust those, senior master sergeants, your chief master sergeants, your master sergeants, and those who have the experience. Trust them to help you. And if you act like you know it all just because you're an officer, then you're not opening your mind enough. And so I think my experiences overall in all aspects of the military have given me a broader base to hopefully be a better judge.
Jim Jonas, co-host of Veterans in Politics. Judge, thank you very much for coming in on Saturday, and I know it's not always fun staring at that bright light, so thank you very much. Thank you very much for your service. So I'm paraphrasing something I came across in Facebook. It was something to do with a prosecuting attorney. He did not agree with the fact that just because the defendant in the case was a veteran, that he should have been able to be diverted straight to Veterans Court. That in fact, he thought that there was actually some constitutionality wrong with that. In the state constitution, it said that just because he's a veteran, he doesn't have a special privilege, even though we do have a Veterans Court here in Nevada. Did you hear anything more specific on that case? And if so, where is that prosecuting attorney going wrong?
Okay, so I'm not sure. I mean, you said that was something you saw on Facebook, and so I hope I'm thinking about the same situation that you are.
Sure.
There was a situation in which a veteran who was charged with a driving under the influence offense made a motion before the DUI criminal judge, and that judge ruled on a motion to allow that veteran into the Veterans Treatment Court. When it got to me as the Veterans Treatment Court presiding judge, there were objections by the district attorney, and I believe that's the same case. Ultimately, I proceeded to take his plea, and he began to enter into the program, and then the district attorney's office filed a writ. Ultimately, they withdrew that writ, and it's no longer pending before the Supreme Court, is my understanding. I've had conversation with both Mr. Wolfson and the attorney who represented that defendant, and that's my understanding. With that said, I know of no constitutional issue that's been raised. The issue that they raised were really more of interpretation of the statute. And that case really brought to light there is a resistance by the district attorney's office to allow veterans to directly come into the program without them being the gatekeeper. So the DA wants to, I think, be the gatekeeper to evaluate a case to determine whether a veteran is appropriate for a diversionary court. Well, the legislature has initiated a statute back in 2009 that gives them gatekeeper role responsibilities, if you will, for violent offenses, but it does not speak to DUI offenses, nor any other type of offense that does not have a violent element to it. So I think when the legislature speaks and the legislature creates a statute, that the statute needs to be followed, and that's our job. I'm not a policymaker, I'm not a legislator. My role is to apply the law. I will say that there are the language in that particular statute gets to be confusing, because in that particular chapter, it defines the court as the district court. In that chapter, it says that the limited jurisdiction courts, the justice court and the municipal court, may transfer original jurisdiction to the district court of a case for a veteran to go through a veterans treatment court program. But then it's silent as to what happens if we may not transfer original jurisdiction. The district court, veterans treatment court is a busy court. Sometimes a misdemeanor defendant can get better treatment at that lower level if they stay in a limited jurisdiction court. I've worked with a number of groups over probably the last couple of months to, discuss problems. I just spoke before Senator Hardy at the state legislature to discuss confusing elements of that statute, and I'm hopeful that in the next legislative session that we'll get some clarification, and the legislature will give us some very clear guidance on how that's to be applied and what their intent was. It appears from reading it that their intent was that the veterans could come into that program.
Thank you very much, I appreciate that.
Hi, Judge. My name is Nathan Atkins, and my question to you is, based on the fact that you're currently a judge and we can look at some of the work you've done, your body of work, right? How will you help us believe that your decisions are always based fairly and impartially?
Well,
In other words, if
Yes.
there's undue influence, right? So it was believed that you were influenced to make a decision favorably for a member of society that has a little more standing. And I'm sure you're familiar with what I'm referring to. So how would we believe going forward that that decision, as well as any decision you make, is equal and impartial for all of us as citizens?
Okay. Well, I can certainly speak to the case you're referencing and any others. I think if you look at my decisions over a history of 9 years and now going into my 10th year on the bench, most people would say I rule fairly, without a bias towards one side or the other. This is what I can say about that particular case, and unfortunately the only public information out there comes from an editorial in the Los Angeles Review-Journal. And what happens in the courtroom is not all there is about any one case. There are, prior hearings. There's information that comes to light through discussions with attorneys in chambers. And in that particular case, I think that any information that was out there in the RJ was not fully informed as to what was going on. And so I'd like to take the opportunity to maybe give some information about what was going on in that case. In that particular case, I made a decision on the sentence. I think it was December 20th of, I don't remember what year right now, let's say it was 2011 or 12, somewhere around there. And what I was told going into that hearing was that a negotiation had been reached and I was going to take a plea. It was about 10 minutes before that hearing that I learned that their negotiation of the case between the defense and the prosecution did not involve a sentence, and I was going to have to sentence an individual. So I, was ready. I had read the case. I knew what the facts were. And I ruled. I made a sentence. It's not an uncommon thing at all in my courtroom to keep people in a position in society where they can meet their family needs, their job needs, their educational needs. If someone's in school, for example, it is not at all uncommon to allow that person to serve jail time on weekends, or a person with a job. I do that on a regular basis all the time for many people. In that case, he was supposed to surrender in the early part of January after the holidays to give opportunity to spend time with his family. And that was not anything that was objected to by either party. When January came, and that case was on calendar, it was the very first time that I was informed, and this was in chambers with defense and prosecution present, that I was informed that there was an event or a job opportunity, contracts that had already been signed. And the information that was available and that was undisputed by the prosecuting attorney was that Mr. Roger, our former district attorney in Cobb County, had been approached back in November, long before I saw the case for sentencing, by the attorney. And the attorney had requested of Mr. Roger permission to allow his client to sign contracts and to obligate himself to this job opportunity that was coming up in the spring. And Mr. Roger agreed and said, you tell any district judge out there if this case is going to proceed to a jury trial, then this won't interfere, he can sign the contracts. And on that reliance, he did. So when it came to me in December, I didn't know that. When it came to me in January, that was the first time I knew about that. And the defense attorney at the time requested of me, because of that, that I delay his, not his entire sentence, his sentence included a multitude of things, including fines, community service, counseling, and things like that, as well as some period of jail time. He made a motion to delay a portion of the sentence, that being the jail sentence, until after his contractual obligation was fulfilled. And it was at that time that the deputy district attorney raised an objection, saying that deal was only good. That deal, and of course the defense attorney cited the agreement that he had with the district attorney. And the deputy district attorney, now you went into the new year and Mr. Roger was no longer the DA. And into that new year, now the deputy district attorney said, oh, well that deal's only good if he was going to a jury trial. And I said, okay, so you enter into an agreement to sign multi-million-dollar contracts, and you then allow him, if he's going to go to a jury trial and fight this and not accept responsibility and take up time and money of our taxpayers, then your deal is good. But once your case, in your opinion as the DA, it's not worth a felony anymore, now it was worth a misdemeanor, and now that he's taking responsibility, and now that he's coming before the court, now that deal's not good anymore, I didn't care who he was. And it had absolutely no aspect of my decision had anything to do with who he was. In my opinion, it had to do with what was right. And when you make an agreement with someone, you stick by the agreement. You don't change the deal and the parameters of the agreement because now he's pleading to a misdemeanor, because now he's taking responsibility for what he did. And I stand by that in the face of public opinion. If you want to know that I can be fair and that I can be impartial and make rulings that are not based on public opinion, I recognize that I took some heat for that decision. But it was the right thing to do. It was the agreement that was reached. And I didn't think that it was right for somebody to back out of that agreement just because he pled guilty or the circumstances changed. That being said, after that, I even sat on the board. I was invited to sit on the board. It was a domestic violence case. And even after that decision, when I get an opportunity to talk about that, I was invited to sit on the board of directors at Safe House, a domestic violence organization. They trusted my decisions to be fair and impartial. I did that when I was running a civil docket and no longer hearing criminal cases, and I don't do that anymore now that I'm back in the criminal docket. But I think that alone, you want judges who have the courage to do the right thing in the face of public opinion and not be persuaded by public influence.
I don't have anything here.
I want to ask a more fundamental question about perceptions. And there's a perception on some people's part when a judge seeks out and receives endorsements from law enforcement that there's a bias. And I wanted you to respond to that perception that people have about our system. how judges rule, how they sign off on warrants, and they give the police the benefit of the doubt. And is there a perception there, perhaps, that they're taking actions in return for seeking those endorsements from law enforcement?
And Robert, I'll pose the question.
I can't speak to those people that have that perception, of course. I guess I can respond to my perception of how that process works. And having sat on those interviews, it is not my impression at all that law enforcement is expecting any judge to rule in any specific way on any case because they endorsed you. I don't think any group out there, whether it's a labor organization or the police endorsement or any of those, are expecting that. I think what they expect is to be treated fairly. And I think what they expect is, for example, some of the questions that I would be posed are things like, are you available when you're supposed to be available? And that is, we're on search warrant duty. We get calls all night long. We get calls on weekends. Whether it's your day for search warrant duty or not, you should be available to an officer. And there are times when officers will attempt to reach a judge and can't get a hold of them. And their questions are more fundamental to things like that, like, you, Judge Saragosa, are you going to make yourself, or do you make yourself available at all hours of the day and night, so that when we need a search warrant, it's not taking our officers an hour to call judge after judge after judge to find the person who's available. Those are their more fundamental questions, and I think they expect those types of things. They expect the judge to uphold their role. I've never gotten the impression in any endorsement interview ever that anyone expects some special treatment or some biased view just because of that. They want to make sure that the judges are doing their job, being fair, taking into consideration an officer who may have worked a graveyard shift and is tired and coming into the courtroom. They want to know, Judge, would you be courteous enough to perhaps call that case if everybody's resolved and let that officer go home rather than have him sit there for the next hour or two while your calendar's going on? Those are the kinds of things they want. And I think it's just courtesy and fairness, nothing to be biased or prejudiced in any way.
Hi, my name is Monty Levy, and I have a question for Judge Saragosa. On March 31st of 2015, you sent a letter to the Assembly Committee on Judiciary with regard to AB 193, which dealt with the use of an alleged victim's hearsay alone at preliminary hearings in order to have a defendant stand trial for felony or gross misdemeanor charges. In that letter, you indicated that you were giving the collective position on behalf of the justices of the peace of the Las Vegas Justice Court, and the letter was signed only by you. Subsequently, several of your colleagues on the bench wrote letters adamantly opposing that bill, which was inconsistent with the position in your letter, which was a neutral position. Can you please explain to the panel the contradictory positions between your letter and the letters that were sent later on by your colleagues, as well as the interviews given to the RJ, where there's quotes from other colleagues adamantly opposing AB 193?
Yes, I can. I am or have been for probably the last, 6 years maybe, the chairman of our legislative committee. In fact, we've only had committee, if you will, more than kind of one liaison for the past session. Prior to that, it was historically Judge Osterly handled that role before her retirement, and I handled that role after. So it was not uncommon in any scenario that as our legislative representative of the bench, that we spoke with a single voice and that I would be the one to carry that message along to the legislature. In this particular bill, it dealt with a number of issues, one of which was whether or not justice court judges could take pleas. That was kind of a major area of the bill. One was the hearsay portion of the bill, allowing hearsay to be used in preliminary hearings and grand jury proceedings. And then the third kind of category, if you will, was whether or not a justice court judge had the authority or should have the authority to rule on motions to dismiss, motions to suppress, things like that that are based on constitutional grounds. The judges prior to that letter, I don't remember the date, maybe a month prior to that letter, had a meeting. And as you may be aware, when you hold a judge's meeting, not every judge can always make it. So at this particular judge's meeting, we have 14 judges on our bench. I want to say we had about maybe 11 judges there at one time, and I know that one left early before we discussed legislative matters due to other obligations. If you're present at the meeting, then you have a voice and you can be heard. If you choose not to, or you're unable to be there, you have the opportunity to, I guess, have a proxy or to convey your feelings on any matter otherwise outside of the meeting. When we had the meeting among all the judges that were there, I gave the judges my thoughts as our legislative person. And my recommendation was, this is an issue that is being fought by the litigants before us. The prosecutors on one side, who are the proponents of this bill, and the defense attorneys on the other side in opposition to the bill. These are the litigants who appear in front of us every single day. We as judges have a judicial ethical obligation to be neutral, to be fair, impartial, not biased, not prejudiced towards one side or the other, which goes back to Mr. Atkins' question, I guess. And so my recommendation to the bench at that meeting was, I think we should stay out of this altogether. We should let these parties, who are well educated and smart individuals, argue this issue. This is a policy that our legislature makes. We're not lawmakers. That's not our role. And we had some discussion about that. At the end of the discussion, I very clearly asked the bench, what do you want me to do? You've heard my recommendation. We've had discussion. What do you, as this group, want me to do? Do you want me to go to the hearing on the bill? Do you want me to represent a specific position? Do you want me to do something? And the entire group that was there at that meeting said, we want you to go. We want to be neutral on the portion of the bill dealing with whether judges take pleas. If the legislature thinks that we should, justice court judges take pleas. On felony cases, and maybe I should explain that a little further, it was a bill that authorized a justice court judge at limited jurisdiction to enter or to accept a plea on a felony or gross misdemeanor, which currently we don't do. That's with the district court. So everyone said, yeah, we'll be neutral. We don't have any interest in that part. We'll let the legislature decide. We also understand that it's policy, and we as the judiciary should stay out of the issue on the hearsay, but we want them to know that we do have concerns about it. We do. We're concerned that this practice, if you will, of allowing hearsay in a preliminary hearing, if that were to, that was what was proposed, and if that were to pass, it may do away with the preliminary hearing altogether in terms of witnesses. And we're concerned about that. We're concerned that it would be overly used or misused. And the third part, we said, you know what, we have an oath. We take an oath of office, and that is to uphold the Constitution of the United States and of the state of Nevada. Why shouldn't we hear motions of a constitutional nature if they're, put before us in the proper manner? Why shouldn't we hear those? We took an oath to uphold that Constitution, and so we should hear those. And we decided, the group decided and gave me direction to oppose that. I came to the first hearing on the matter before the legislature to convey those exact thoughts. That hearing got continued, and no one got an opportunity to present any testimony in favor of, opposed to, or neutral on the bill. And it got continued to another day. When it got continued to another day, our chief judge, Judge Bonaventure, was out of town, and I was doing my military reserve duty at the Pentagon. And I couldn't be at the next hearing to present the judiciary's position that they had given me direction for. So among discussions with the chief judge, I said, what should we do? Should I do nothing? Should I get somebody else to handle that for us? What should we do? One option always is to present information to the legislature in the form of a written letter. And that was the direction that I was given from the chief judge, write the letter. And I asked our staff attorney, Joe Tomasino, to gather the minutes, because I was already back in DC. I said, please gather the minutes from this judge's meeting and draft a letter consistent with the minutes so that I can sign it and have it sent to the legislative committee. And that's exactly what happened. I thought the letter fairly represented the direction that I was given amongst the judges that were present. I understand after that there was a letter written to the judiciary from a member of the defense bar who was very angry about the letter. It was not the position that he wanted the judiciary to take, and he attempted to use some influence to encourage us to change the position. He didn't like the use of the word collective, and in essence requested the judiciary, specifically me, I guess, the letter was directed to the Chief Judge Bonaventure, but copied to all of us, that I recant the letter, that I retract the letter, that I change the letter somehow. Feeling that the letter accurately represented the meeting that we had, our staff attorney drafted it in accordance with those minutes. We discussed it. Judge Bonaventure went to every judge on the bench and said, do you want us to change the letter, retract the letter, recant the letter? And Judge Bonaventure, after talking with the entire bench individually, determined that there were some judges who were upset, 2 that were not at the meeting, some that felt like maybe they should put their personal position forward rather than the position that we came up with and were given direction of that meeting. But everybody felt that the letter accurately reflected what happened at that meeting. And so no action was taken to change the letter or correct the letter because it was accurate. Subsequent to that, several judges wanted their personal position to be set forth. Some may have changed their position given further thought and deliberation. And they wrote those letters to the judiciary, to the assembly, so that the assembly had them available when they made a decision. Ultimately, that bill was amended in substantial form and allowed minimal areas where hearsay was admissible. Those were very unique cases involving child victims and victims of domestic violence. And otherwise, the bill did not pass in its original form. And that's pretty much what happened.
And Judge, thank you for your time and
Thank you.
questions. Normally, we would be going to the next interview. However, there's been some cancellations, so if you have time, I know half the panel we didn't get to. If you can stick around and maybe answer some questions individually, that'd be great. I know you're always open and you're always ready to answer questions, and that's why I let that one go on, because that was a big issue in the legal community. So I appreciate your honesty and straightforwardness. So at this time, we're going to break for lunch. We have a few other judges here. I'd like to thank Judge Saragosa.